The Committee on Criminal Jurisprudence will come to order, and clerk, please call the roll.
Chair Smithy,
Aye, here.
Vice Chair Wu,
Here.
Representative Bowers, Representative Cook,
Here.
Representative Jones,
Here.
Representative Little,
Here.
Representative Louderback, Representative Money,
Here.
Representative Moody, Representative Rodriguez Ramos, Representative Verdell.
Okay, a quorum's present, so we'll go ahead and begin. Members, thank you all for being here early this morning after a relatively late night. And we, as a reminder to those of you wishing to testify, we're glad you're here. We would ask that before you testify that you fill out an electronic affirmation out in the hallway. And if you haven't done that already, if you would do it. Also to remind you that if you wish to register for, against, or on a bill without testifying, you are certainly free to do that as well. To accommodate the witnesses and the time that we have allotted today, we've placed a 2-minute limit on witness testimony, which will be strictly enforced out of fairness to the witnesses. And I will remind the witnesses and also all of us on the committee to refine our discussion, to confine our discussions to the matter being considered by the committee. And so if there's no other business, the chair will begin hearing these bills. First of all, the chair would recognize Representative. Where is Thompson's bill? Which one is it? Oh, the chair will recognize Senate Bill 1804 and recognize Vice Chair Wu.
Thank you, Chairman. So I'm laying this out for Ms. T, and this is Senator Alvarado's bill, 1804. This is a great bill. Let me just read you the packet so I'll make sure I don't miss anything. Current law allows courts to order payment for medical and mental health treatment through the Crime Victims Compensation Program, but does not allow for tattoo removal for victims of human trafficking. For many survivors, these tattoos are physical reminders of the trauma that they experienced, often branding them with a trafficker's name or symbols. SB 1804 supports the recovery of human trafficking survivors by allowing courts to order restitution to cover the cost of tattoo removal in cases where tattoos were applied through force, fraud, or coercion. This extends this eligibility to all victims of trafficking regardless of their age. And let me just add a couple things in the notes, and so I'm just going to tell you some of the things out of the Q&A so you don't have to ask. So the fiscal note on this is about $42,000. They expect the bill has a cap of $3,000 per removal, and the person requesting removal has to apply through the Office of the Attorney General, and basically the tattoos have to be a part of the crime. Like it can't just be some random tattoo that they want removed. That it has to be acknowledged that this is a human trafficking tattoo or something like that. Part of the reason this has to happen is the current law only allows some under 18 victims to have access to this, and many of the victims they're victimized well past their 18th birthday and would not be eligible otherwise. So this bill takes care of all that, and it's a very, very small part. And if you're concerned about the funding, appropriations put through millions for the Crime Victims Compensation Fund to compensate for the loss of some of the federal funds. So I'm happy to take any questions.
Okay, first I need to note that Ms. Rodriguez Ramos is present. Thank you for being here. Any questions for Mr. Wu, who's filling in for the bill sponsor? Okay. If not, we have one witness that has registered. It would be Brody Burks. And you've registered as Brody Burks here on behalf of the Office of Attorney General, and you're testifying on the bill, correct?
That's correct. Chair Smithy and members, thank you so much for allowing us to be here today. Just very quickly, I want to lay out kind of what we are seeing in this. I tried a case this past summer that involved a minor victim. She had actually been tattooed by her biological father, who was her trafficker. The tattoos that we were seeing in that case were related to his membership in the Aryan Brotherhood of Texas. He joined AB while he was in prison on another offense, and he forced her and applied tattoos to her that matched his own Aryan Brotherhood tattoos. So obviously that was not something that she wanted to have going forward in her life, and so this would allow us then in those sorts of cases to use crime victims' compensation funds in order to do that removal. I'm happy to answer any other questions that you have.
Okay, thank you. Any questions, members, for Mr. Burks? Mr. Louderback?
Thanks for testifying. This is very common practice in the criminal world, in the cartel world. But is this, and maybe maybe Representative Wu would know this, is this laser removal?
I don't think it specifies what type of removal. I think just whatever works best for that
whatever,
situation.
okay.
I would assume it's laser, but it doesn't specify in the law.
That's correct, and that gives us some flexibility to pursue whatever would work best for the victims in that case, but that would be my assumption in most of these cases as well.
Okay, any other questions? Mr. Munn?
I mean, I think this is a good bill. How often does this happen? I hear the fiscal note's only 42,000.
And it's limited to $3,000 per.
Right, so that's up to 14 people, which seems small. It also allows, I guess, for traffickers to have to pay it, which would offset some of that cost. But how often do we have the trafficker and are able to go after them to get the money?
Sure. So what I would say is we're seeing this probably in 50% of the cases. A lot of that depends on how long a victim is trafficked. One of the cases that I prosecuted this summer, the trafficker was only with that victim for about a week. That was not long enough that happened. But any time that we see a victim who has been with their trafficker for very long, we're seeing that. As far as restitution goes, most of the time these are traffickers are sentenced to prison. And so that is not then, we don't have some long probation for them to pay that out of. I will tell you that so we had a case where we were seeking restitution. We had a very large fine as well. We do go after their commissary accounts. We will file for those commissary accounts to be drafted against, and so we will recoup some of those funds that way.
I mean, but is 42,000 enough? I mean, that's not very many.
It's not an appropriation, like it's not an appropriate amount appropriated. The fiscal note basically says that out of the monies in the Crime Victims Compensation Fund, about $42,000 will come out to pay for these stuff. But the Crime Victims Compensation Fund is both funded by state, federal, and money that's assessed on defendants.
Okay.
So that was just an estimate that we came up with, kind of looking at the cases that we had. Obviously, there are some county-level cases where a local DA has those cases and may then apply for funds. It's a little hard for us to have a whole lot of visibility in what that looks like, but we worked with Crime Victims Compensation to see what they were seeing in sort of in our trafficking funds generally, like for mental health or some of these other things that we currently can use those funds for, and that was the estimate that we came up with.
Okay. Thank you.
Any other questions, members? Okay. Thank you very much for being here, Ms. Burks.
Thank you very much.
Okay. Anyone else here to testify for, against, or on House Bill Senate Bill 1804? There being none, Mr. Wu, you want to close on behalf of Representative Thompson?
Yes, thank you, Chairman. I think this is a fantastic bill, and I hope we vote it out. Thank you.
Okay. Are you vote on this now? Okay. Members, does anybody have any objection to voting on this now? I don't know of any opposition to it. Okay. We might as well go ahead and vote on it then. Mr. Wu makes a motion that Senate Bill 1804 be reported favorably, referred to the Calendar Committee with a recommendation that it do pass. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers, Representative Cook,
Aye.
Representative Jones,
Aye.
Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell. 10-0, 1 absent.
Okay, so by the motion, by a 10-0 vote with one absent, the motion prevails. At this time, the chair would lay out Senate Bill 535 by Senator Huffman and recognize Mr. Capriglione to explain the bill.
Great. Thank you. Good morning, Mr. Chairman and members. Today, I'm here to present Senate Bill 535, a bill that expands Texas's Rape Shield Law, Rule of Evidence 412, to better protect victims of human trafficking and child-specific sex crimes. Under current law, Rule 412 excludes evidence of a victim's past sexual behavior or reputation in cases of sexual assault and aggravated sexual assault. However, it does not extend those same protections to victims of other serious sexual offenses such as trafficking, continuous sexual abuse of a child, indecent assault, or indecency with the child. Senate Bill 535 closes this gap by ensuring that all victims of major sexual crimes are treated with the same dignity and legal safeguards in court. Specifically, the bill expands Texas's rape shield protections to include trafficking of persons, continuous sexual abuse of a young child or disabled individual, indecent assault, and indecency with the child. In addition, the bill makes clear that reputation and opinion evidence regarding a victim's sexual behavior is inadmissible across all covered offenses. However, it does preserve the exception allowing specific instances of past sexual behavior to be introduced when lack of consent is at issue, preserving fairness in the judicial process while protecting victim privacy. This legislation recognizes that victims of trafficking and child sexual abuse face profound trauma and deserve the same protection afforded to survivors of rape and aggravated sexual abuse. Senate Bill 535 sends a clear message. Texas stands firmly with victims of sexual violence, and our laws must reflect that commitment. Happy to answer any questions.
Any questions for Chairman Capriglione? Mr. Little?
Thank you, Chairman Smithy. I just have one question. I don't, Representative Capriglione, please don't feel bad if you don't know the answer to this, but I read through this bill, and it's good that there are exceptions within subsection E on page 2, but there's an exception E2, gives the court an opportunity to determine whether that information is admissible.
Yep.
And there's one exception, E2E, if the information is constitutionally required to be admitted. Does anyone know what that means?
I'd have to find out which constitutional requirement does. I only imagine that's in there in case there ends up being something in the Constitution that does it, but that would be obvious, right? I don't. I don't know
Yeah,
if you're asking something else.
if someone else on the panel knows what it means, I would love to know. Thank you.
We may have, Mr. Wu?
My guess would be, it might be something like a Michael Morton type of disclosure that has to be made.
Okay.
It's required by law.
Okay.
We do have a couple of witnesses, so.
Thanks, Vice Chair.
Maybe one of them will know. Any other questions for Mr. Capriglione? Okay, thank you, and we'll
Thank you.
reserve the right to close for you. And Alan, well, let's see. Alan Place is here. And Mr. Place, you've registered here on behalf of Texas Criminal Defense Lawyers Association against the bill.
Yes, that's correct, Mr. Chairman, members. Our objection to this is very pointed. I'd ask you to look at Section 2 of the bill. Basically, what the bill says, it's a rendition of current law, which is Texas Rules of Evidence 412. We have no objection to the rape shield law. It's fine. Our objection is if the legislature wants to broaden the offenses of which it applies to, then I think that's certainly y'all's prerogative. I think the issue that we have is the current rules of evidence is considered to be a judicial function of the Supreme Court and Court of Criminal Appeals. And by basically disproving in Section 2, if that is taken out, then I think y'all can certainly do whatever the votes are there for. But what you're going to have if this continues with the precedents, is you're going to have a different civil rule than you are in criminal rule. And I'm not sure that's the best way forward. So our objection would just be to remove Section 2.
Okay, any questions for Mr. Place? Mr. Little?
Thank you, Alan. So what is, I haven't parsed the differences between Rule 412 and this proposed bill. Can you tell me briefly what they are?
Well, as I understand it, the guts of the bill are basically, they track Rule 412. I think what it does, it adds, let's see, in Section B1, it adds trafficking, continuous sexual abuse, indecency, and indecent assault. I think the current Rule 412 just addresses 5 and 7, which is sexual assault and aggravated sexual assault. So this adds additional offenses to the rape shield law as I read it.
Okay, and I'm reading Section 2. It says under the terms of under 22-109B of the Government Code, Rule 412, Texas Rules of Evidence, is disapproved. And I'm wondering, can we even do that under the separation of powers?
Well,
Yes.
that's the heart of our objection, is that there is a committee, basically, that sits in calmer situations that perhaps we're in today and make those sort of decisions. And we think that, they are the best committee to basically come forward with the rules of evidence for criminal and civil. And so, I'm with you. If not your question, it's if you can do it, if this is the prerogative, should you do it, I think is the other question that we would have.
It may simply be, Mr. Place, that we have the power to do that, and I'm unaware of it, but my understanding is that falls within the province of the judiciary to promulgate these rules. And obviously, we do things that affect them every day. Like,
Sure.
We're changing the Code of Criminal Procedure that has evidentiary effect, but I'm curious whether we have the ability to disapprove of rules that are established by the Supreme Court.
That's our basic concern, is that we think that's better handled in the judiciary.
Thank you, Mr. Place.
Ms. Jones?
I guess I'm bothered by removing rules of evidence which seek to make sure that evidence is, first of all, reliable, that it's reasonable, that it's authentic, and that it's reasonably related to the crime that someone is charged with. And if we can just admit what we want and don't have to follow the rules of evidence, that concerns me. I think it is, I don't know what that fix is, but the rules of evidence are there for a reason. So, and if we disprove, assuming we can do that, if we disprove Rule 412, who's to say we can't disprove all the rules of evidence? And it's the wild, wild west of admitting evidence in these types of cases. I think it's a slippery slope, and I'm concerned about that. I certainly understand trying to keep out evidence of past sexual behavior, especially if you are a victim of a sexual crime or you're a victim of human trafficking. Sure. But I just don't know that. I just need to think about it.
Well,
but that concerns me a lot.
I think I do want to clarify that basically this bill tracks 412 in terms of the substance of it. Okay. On the other hand, the circumstances, you have a committee of individuals from all parts of the courtroom, prosecutors, defense lawyers, judges, that basically meet and decide. And it's not an easy task, but they basically try to see what works and what's right. And so, the circumstance is, our concern is that seems to be left best to the judiciary in our opinion.
And there's a way, through the rules of evidence as they exist, to keep out that kind of evidence anyway. So I just need to think about it.
Understand?
I'm trying to look at, I'm sorry, I'm trying to look at both things. I mean, like, this is the way I think, tell me if I'm wrong. I think if we pass this bill, this section 2 would strike the existing 412. The Supreme Court would then need to reform a committee to redo 412, and most of this bill is mostly 412, and they would, what I would guess is the Supreme Court would reform a committee and put together another 412 section based on this law, and they would just reinstate most of 412 with the additional parts of this into 412. And I understand like the difference between a committee of lawyers and judges coming up with a rule and then versus the legislature jamming it down your throat and saying, hey, this is what the rule is going to be, right? I understand that very much, but I don't think that we're not getting rid of 412 as much as replacing it is my understanding. I'm not saying I'm sold on this either way, but is that?
I think that the committee can meet at their pleasure and and address any situation where the legislature acts or not, and my understanding is that is what they do. Our reading of Section 2 is Rule 412 is disapproved if you keep Section 2 in the bill. So, I mean, disapproved is not, I mean, I think that's pretty clear what that means if you leave Section 2 in the bill.
But we have other parts of our rules of evidence for civil or criminal that are modified by statute, right? That the rules generated by lawyers go up to here, but the state law says on this back end, on this one small piece, you're gonna follow what we say, right?
Well, let me suggest to you this as well. You see in Section 1, you're adding this section. So the truth of the matter is the Rules Committee is out in front in terms of putting out the rape shield law. I mean, that's basically the law as we sit here today, regardless of what happens to this bill. That's the law today, and they were ahead of it. I mean, they were doing their job in our opinion.
Absolutely. I totally agree with that.
Does that make
And the
sense?
legislature is behind the ball in this.
Well, I think the
but
circumstances, that can be added to, but I think it can be added to without disapproving of the rule.
Don't disagree. Don't disagree. And that's kind of like, I think, maybe a question for the bill author and others is like, why do it this way? Why not just have a bill that modifies the existing Rule 412?
I agree.
Yeah.
Mr. Little?
Mr. Place, I'm just going to make a couple of other observations. So the offenses that are added under this bill that would be kind of scooped within the rape shield law, two of them are trafficking offenses, trafficking of persons and continuous trafficking of persons. I'm sorry for my lack of imagination, but why would we need to introduce the sexual history of the victim in a trafficking prosecution?
Mike?
Or why would anyone want to do that as a defendant?
Well, I think that in our reading of it, it's probably going to be a limited instance. I think in the bill layout in the Senate, as I recall, certainly a trafficking of a person can also bleed over into sexual type offenses as well.
Sure.
Kind of thing. And so I think that's part of it. But for example, it's kind of hard, like indecency with the child. I'm really trying to...
I don't think we're going to get into the kid's sexual history
I can't,
as a defense of any kind.
I can't see how that would necessarily actually work in a real life situation.
I can't either. I'm kind of at a loss for why those are in here. Like, I don't want to be glib about it. I just don't know why that information would be sought to be introduced by a defendant.
I can't see it I can't see it in reality in some of that circumstances. You know, I do think this body has the ability, you know, to address something in terms of if it's needed and broader than current law. But I do think it's just not a great idea to overrule the committee in terms of a set rule that is published, you know, to every lawyer, regardless of which side of the room you sit on, and every judge.
Any other questions for Mr. Place? Mr. Cook?
Yeah, I don't know if it's for Mr. Place and/or the general counsel, but just, I mean, what the difference in between repealing this versus disapproving it? I mean, I think the fact that it's using the word disapprove means that we probably don't have the authority to do it. Otherwise, would it just say that that portion is repealed? Or it means, because I think, I looked up just to see what disapprove mean. I think it's just expressing the legislature's intent is, you know, we disapprove it, that's our intent. But I'm just curious why they would have left
The government code that tracks there uses that language. Of course, you know, candidly, that's language this body wrote as well. So I'm not sure where that takes us. You know, the circumstance is, our reading is that, again, if you wanted to just, if you didn't have Section 2, you're going to have an evidentiary section under Section 38 that basically incorporates current Rule 412 and adds it to some other offenses. And so to me, it's kind of a strong statement, and again, it's separation of powers, and I think I understand that on some days I don't. But I think it's a little broad if, in fact, it's a good rule that they came up with that is working well, and basically, it's fairly understood. And I just want to be clear, you know, our association doesn't have any issue with the fact of Rule 412. I mean, that's been the law, and we're good with that. I mean, that's been the rule of evidence for, I can't tell you how long, but for certainly a while. So I'm not sure the terms are as clear as they perhaps want to be, Chairman Cook. That's kind of my take.
Yeah, thank you. Appreciate it.
Okay. Any other questions? Yes, Mr. Riddell?
Thank you, Chairman. This is definitely outside of my scope of what I do and outside of the legislature, but is this something that, I'm just trying to understand, is it something that, let's say that you are the defense or you're the person accused of something, is it saying that you could introduce evidence that would show that the person making the accusation has a past history of doing things like that?
Basically, that's the current rule of evidence, is that if there was a case today, what you stated is the general rule. And if you read into the weeds on this, it says that a defendant may not offer that type of evidence unless, number one, there's an in-camera examination by the judge. They have to weigh out the probative value versus prejudicial effect. And then it lists a few situations where a judge can admit it. And so the general rule is that you're not going to be able to go into that prior history. Okay, that's current law under Rule 412. Okay, but there are some exceptions. And how we read this is the author has done a good job of putting that Rule 412 exactly tracked in here. I mean, it's written a little bit differently, but a complete reading of it says they are incorporating this, but just adding new offenses to it, because I'm not saying it's restricted to it, but when it was written, it only applied to, my memory, sexual assault and aggravated sexual assault. So you're just adding to it as I read it.
Okay, appreciate that.
You
Thank
bet.
you. Yes, sir.
Any other questions? Okay, thank you, Mr. Place, for being here. Is there anyone else here who wishes to testify for, against, or on Senate Bill 535? If not, the chair recognizes Representative Capriglione to close.
Mr. Chairman, members, so just to answer a couple of things. First of all, it took us all of 30 seconds to find cases where the defense aimed to introduce evidence that the child victim had previously been sexually abused and contended this information was crucial to challenge the state's evidence. We found 2 or 3 cases. So this can occur. I'm not saying that this happens all the time, but obviously we have a rule that says that you can't use a person's past sexual behavior to say it was their fault to be raped, okay? And that's been around for 46 years, okay? No one's had a problem with that. What we're saying is that we have seen some cases where people in other crimes or alleged crimes of indecency with a child, aggravated sexual assault, continuous sexual abuse of a disabled individual, where the defense has tried to say that it's their fault that they were raped. And what this bill is saying is that we're the legislature, we created the rules of evidence statutes, the federal government created with Congress those rules of evidence. We're saying that this should be expanded, that this should include other victims of sexual abuse. I close.
Okay, any questions for Mr. Leon? Oh, Ms. Jones?
I just want to say something and let you know, and maybe we can figure it out, or maybe I can figure it out with you. Let me just tell you from my perspective. So under text rule of evidence 412, evidence of a victim's prior sexual behavior, often referred to as prior bad acts, is generally not acceptable in sexual cases. However, there are limited exceptions where evidence may be admitted if it meets strict criteria. So the general rule is evidence of reputation or opinion about a victim's past sexual behavior is never admissible. Evidence of specific
Now,
instances.
what you're talking about is for someone who is raped. And you're talking about the current law.
No, I'm just talking about the current law.
Yeah.
Like I'm just talking about current law.
Yep.
Evidence of specific instances of past sexual behavior is presumed inadmissible unless it falls within some exceptions. So under Rule 412B, defendant may introduce specific instances of the victim's sexual behavior only if it's used to rebut or explain scientific or medical evidence.
Right.
It involves past sexual behavior with the defendant to show consent. It shows the victim's motive or bias. It's admissible under Rule 609 for prior convictions, for impeachment, or it's constitutionally required to be admitted to preserve a defendant's right to a fair trial.
Sure. Yep.
The procedural requirements of Rule 412C, the defense must notify the court before or during trial, outside the presence of the jury. The court must hold an in-camera hearing, which is where the court looks at it, right? I know you know that. To assess its admissibility, the judge must balance the probative value against unfair prejudice to the victim. So in short, evidence of a victim's sexual history is heavily restricted and only allowed under narrow court-reviewed exceptions to protect the victim's dignity and ensure a fair trial. So all I'm saying is, at least in my practice, I've seen where that works, where they're trying to say a prostitute can be raped because they're a prostitute. Generally, and I will respectfully suggest to you that most prostitutes are victims of human trafficking.
Right.
Right. So, at least as I've seen it in my practice, that stuff is almost always kept out anyway. I just haven't seen in trial, and so that's what I'm struggling with, because that stuff is already kept out mostly.
For all of these other provisions that are listed in this bill?
I'm sorry, say it again?
Well, so you're saying that that is mostly or generally kept out, or are you saying it's always kept out? And are you saying that's always kept out for the 4 things that are added in this bill?
I mean, it's sort of just generally.
So generally is different than always, and so what this bill does is saying always.
Well, no, I know that.
Okay, well that's
so
right.
I know that.
Okay.
But that's like major. First of all, like I said, at least in my practice, I've seen it happen rarely.
But still happens, and so that's why we're working on this law, right? To make sure that it never happens, that the reputation or the rumors of an individual's past sexual behavior, if they happen to be a child, should never be, other than with the exceptions that are listed in this bill.
Like I said, I just want for you to know my struggle, because I believe in the constitutions and the laws promulgated to protect the Constitution. And so when we start
Absolutely.
whittling away at the Constitution, it just scares me. In any case, I just want to let you know that. But
Sure.
maybe I can get there.
Okay.
We'll see. Thank you.
And you can work with Ms. Jones on that if you would. It's a Senate bill, you got a little bit of time, not much.
Okay.
But okay. So if there's no other questions, the chair at this
Thank
time
you.
will leave House Bill Senate Bill 535 pending for now. At this time, the chair lays out House Bill 3207, recognizes Representative Dean.
Morning, Chairman.
Morning.
Vice Chairman Wu. Hope y'all are doing good today. Chairman, I have a committee substitute for HB 3207. You don't usually see me here in the criminal.
Let me let Mr. Cook lay out the substitute to 3207.
Okay,
He lays it out.
we're good.
Okay.
I'm gonna call you chief. We ready to go?
Yep. Go ahead, yep.
Okay. Normally not here, but my local Gregg County District Attorney called us and asked to work on this bill for him. In September of 2024, an on-duty Gregg County Deputy Sheriff was hit by an intoxicated individual. Thankfully, the deputy did not sustain life-threatening injuries, but was injured. The DA told me that he was not able to charge the perpetrator with an appropriate charge because the intoxication assault crime currently requires seriously bodily injury. But in this case, there were no life-threatening injuries. The committee sub for HB 3207 would add bodily injury to a peace officer or judge while on duty to the crime of intoxication and assault. While the penalty for serious bodily injury would remain a third-degree felony, for bodily injury to a peace officer, the penalty would be a state jail felony. I'm not critical. I'm not a criminal lawyer or any kind of lawyer, and I know most of you are, but I'll do my best to answer your questions. I ask for your favorable consideration for the opportunity to close.
All right, any questions for Mr. Dean? Now, I will say we don't have any witnesses registered to testify, so let me hang loose there and let me just ask, is there anyone here to testify for, against, or on House Bill 3207? If not, Representative Dean, if you want to close.
Thank you, Chair. Committee, I close.
Okay, thanks. Members, obviously it's a House bill. If we don't vote on this today, does anybody have an issue or problem you want to work with, Mr.?
I need to look at it. Like
Okay.
I just haven't had a chance.
Okay, if Ms. Jones gets a chance to look at it today, maybe we can vote on it later. We'll be here for a little while anyway. Thank you, Mr. Dean.
And I'll be available,
Okay.
Rep. Jones.
Okay, thank you.
So, Mr. Cook, you ready to do yours? Okay, at this time, the chair recognizes Representative Cook to lay out and explain Senate Bill 660, I'm sorry, let me go back just, I said I left 3207 pending, didn't I? For now?
Yes.
Okay. So the chair,
Wait, I don't think Richard said that.
oh, okay, back up to House Bill 3207. Is there any objection to the withdrawal of the committee substitute? There being none, the substitute's adopted, and the substitute is withdrawn. And if with that, the chair will leave House Bill 3207 pending for now. Now the chair lays out House Bill 535 and recognizes Representative. I'm sorry. It's early in the morning, so I'm sorry. Back up. Okay. The chair lays out Senate Bill 664 and recognizes Representative Huffman or Representative Cook to lay out the bill. Tongue title.
Thank you, Chairman. And if it's okay, I'd like to lay it out from here, but that's okay with you, Chairman Smithy? I'll do it here.
Yes.
Okay, thank you. All right, a magistrate in Texas is a judicial officer who presides over certain criminal cases and some civil actions. Under Chapter 54 of the Government Code, 25 different counties have their own qualifications for standards with regard to hiring and firing processes, jurisdictional powers, and other governing statutes for their local magistrates. Senate Bill 664 provides statewide standards and accountability and creates statewide uniformity by requiring a magistrate to be a resident of Texas and the county in which they are appointed, to be licensed to practice law in the state of Texas and be in good standing with the State Bar of Texas, to not have been defeated in the most recent election, judicial election, and to not have been removed from office or resigned in lieu of removal from office, and to remain up to date with required training relating to bail. To ensure proper oversight and accountability, Senate Bill 664 also clarifies that Chapter 54 magistrates' eligibility for certain removal provisions through the State Commission on Judicial Conduct and directs the local administrative judge to provide oversight over the magistrate. Additionally, upon recommendations from the Texas Judicial Council, Senate Bill 664 adds similar language license requirements to Chapter 54A for associate judges. Be glad to answer any questions. Would like an opportunity to close when appropriate. Thank you.
Any questions for Chair Cook? Okay. If not, we show no witnesses registered to testify. Anyone here to testify for or against or on Senate Bill 664? Chair seeing no one, Mr. Cook is recognized to close.
Thank you, Mr. Chairman. I close.
Okay. And so with that, members, do you we don't have a lot of members here. We may leave this pending for now. So if there's no objection, the chair will leave Senate Bill 664 pending. Now the chair lays out Senate Bill 1019 and by Senator Huffman, and it's the House sponsor is Representative Hall, but my understanding is Mr. Cook's going to lay it out as well.
Yes, Chairman.
So Mr. Cook is recognized for
All right,
that.
thank you, sir. Thank you, Chairman Smithy and members, for the opportunity to lay out Senate Bill 1019, which is, again, Senator Huffman's bill, and the House sponsor is Chairwoman Hull. Basically, with regard to Senate Bill 1019, this is a cleanup where the Texas Human Trafficking Omnibus Bill from last session raised the age limit for alleged child victims to receive support from an outcry witness in criminal proceedings involving sexual assault and trafficking offenses, increasing it from a child younger than 14 years of age to a child younger than 18. However, this change in the Code of Criminal Procedure was not placed in the Texas Family Code. As a result, in sexual assault and trafficking cases handled in juvenile court, an alleged victim may only be supported by an outcry witness if they are 12 years or younger. And what Senate Bill 1019 does is fixes that by addressing the discrepancy in hearsay statement admissibility between criminal and juvenile proceedings by raising the age limit for an alleged victim to receive support from an outcry witness from 12 years or younger to 18 or younger. Additionally, to ensure consistency across legal codes, the bill explicitly defines, quote, persons with a disability by referencing Section 22.04 of the Penal Code, aligning the definition with a disabled individual. Overall, Senate Bill 1019 enhances protections for vulnerable individuals by standardizing the admissibility of hearsay statements across legal proceedings and clarifies the definition of a person with a disability across the legal codes. And I'm happy to answer any questions. And if no questions, I'd like an opportunity to close when appropriate. And thank you.
Okay, certainly. And any questions for Mr. Cook? If not, the chair, we have one witness who is registered. The chair calls Rachel Carrico. And Ms. Carrico, your affirmation shows you're Rachel Carrico, Assistant District Attorney here on behalf of the Criminal District Attorney's Office in Dallas County, John Creusot. Is that correct?
Yes.
And you're for the bill, right?
Yes.
Okay.
Thank you, Chairman and esteemed members of the committee. As you just indicated, my name is Rachel Carrico, and I am here on behalf of my boss, Criminal District Attorney John Creusot. I am the Deputy Chief of the Juvenile Division in Dallas County. SB 1019 addresses a critical gap in the law relating to sexual offenses prosecuted in juvenile courts. This bill conforms the Family Code to the outcry witnesses to allow outcry witnesses to be utilized in juvenile court when our victims are 18 and younger, mirroring the Code of Criminal Procedure you all have updated over the last several sessions to increase that age to 18. Specifically, it will bring it in line so that our provision, which is currently limited to age 12 years of age or younger, rises to that 18 or younger. It protects those victims who are 13 to 18 by allowing that critical support for their personal experience to be discussed in a courtroom in front of strangers, which is often difficult for young victims. We want to have the same opportunity for an outcry witness as those who are in the adult system. This bill does not alter the juvenile process. It enhances it by giving victims a stronger voice and ensuring their trauma is not compounded by a restrictive legal framework. I'd like to share a pending case that is in our courthouse. In 2 weeks, we are set to pick a jury where our victim is 15 years old. She disclosed to her brother. In our case, there will be no outcry witness because her story can't be heard because the perpetrator was a juvenile as opposed to an adult. Her brother will never have an opportunity to share those intimate details of how his sister disclosed to him and exactly what she said to him. Had he been an adult, the perpetrator, however,
Let me see if
that
there's
story
any
would be whole.
questions. Well, you've got another minute or so. I mean, another 30 seconds. Okay.
Thank you. This is not just a legal technicality. It's a failure to provide justice and support to vulnerable young victims. This bill is about creating fairness and equity in our legal system, ensuring that victims of juvenile offenders have the same opportunity to have their voices heard as those in the adult system. I ask for support in passing SB 1019 so we can better serve and protect our children and give them the justice they deserve.
Okay. Thank you, Ms. Grieco. Any questions? Thank you for being here. Anyone else here to testify for or against or on Senate Bill 1019? If not, Mr. Cook, to close.
Chairman, if there are any questions, happy to answer. Otherwise, I close.
And so if there's no questions, the chair will leave Senate Bill 1020 pending. I'm sorry, we'll leave Senate Bill 1019 pending. Now the chair lays out House Bill 1020.
Senate Bill 1020.
Yeah, the chair lays out Senate Bill 1020 and recognizes Representative Louderback to explain the bill.
Thank you, Chairman. Vice Chair, members. Senate Bill 1020 is designed to close important information loopholes created by inconsistent data collection related to GPS monitoring. Currently, bondsmen are required to report to the judge handling the case of a person out on bond if they fail to comply with bond conditions. But it's not clearly defined in statute if failure to comply with GPS tracking requirements must be reported. Additionally, a bondsman's office is not required to notify the DA of failure to comply. Further, certain judges have decided that data related to failure to comply with ankle monitor requirements are judicial work product. This means that DAs cannot obtain GPS tracking data without seeking an order, which put law enforcement at a time disadvantage when the information is not shared. Senate Bill 1020 is a reporting bill that closes data gaps. It does three major things. It requires bail bondsmen to notify the attorney representing the state in addition to the judge and person's attorney if the bondsmen suspect their client is violating GPS monitoring. It requires community supervision agencies overseeing a person out on community supervision to timely notify judges if they suspect a person is failing to comply with GPS monitoring. It clarifies that ankle monitoring data is not judicial work product, allowing all relevant parties to have the data. It also allows community supervision agencies to release ankle monitoring data to the judge, DA, and the person's attorney. This bill passed Senate 30-1, is supported by Texas law enforcement, and received no opposition in committee. I do reserve the right to close.
Okay, and we will certainly do that. And so we have two witnesses registered. First of all, Marnie Conrad. And Ms. Conrad, you're shown as registering for as Marnie Conrad.
That's correct.
Here on behalf of yourself, and you are for the bill. Is that correct?
That's correct. Good morning. On the afternoon of August 22nd, 2019, my son went to a playground near our home to meet a friend. I don't know if you remember me, I had testified on another bill. So I wanted to speak on SB 1020 because no one was monitoring the felon who accosted my son on this playground. He shot him twice and left him for dead, and he went home to brag about it. He recorded the entire event on his cell phone. And this was something that he did on a regular basis. No one was watching him. And he was posting everything to social media. He knew that no one was watching him. And when he was arrested and it all came to light, no one wanted to accept responsibility for not watching him. So SB 1020 is something that I wholeheartedly support because we need accountability, not just for these offenders, but for the people who are charged to watch them and keep the rest of us safe.
Well, I think we're all sorry for your story, but we do appreciate you. I know it's not easy to come and share that with the committee, but we appreciate you being here. So let me see if there's any questions, members. Okay. Thank you again so much for being here.
Thank you.
Members, we also have Andy Kahn here from, and I will say, Mr. Kahn, you've registered as Andy Kahn on behalf of Crime Stoppers Houston and yourself testifying for the bill, correct?
Correct. Thank you, Chairman. Thank you, members. My name is Andy Kahn. I'm Director of Victim Services for Crime Stoppers of Houston, and we're here in support of Senate Bill 1020. Senate Bill 1020 originated from a particularly horrific case, of course, in Harris County, in which a off-duty deputy was picking up dinner for his family and was shot and killed ambush style by two defendants who, ironically, not pertaining to this bill, but both defendants were out on bond for murder and capital murder. Both of them were wearing an ankle monitor at the time. When we found out who the suspects were, prosecutors, law enforcement had to jump through hoops, file all sorts of subpoenas just to get basic questions answered about the defendant's ankle monitor that should have been immediately answered, not 36 hours, not 72 hours, but right then and there. You shouldn't be having to file paperwork to get information on a defendant, particularly a defendant on bond, on their ankle monitor, which can show their whereabouts. I just was dumbfounded that you had to jump through hoops on that. And to show you how perilous this situation is, the numbers in Harris County that I'm about to read off to you from the Harris County Pretrial Services Division will probably make you wonder, why hasn't this been done before? 2019, there were only 600 defendants. I'll finish very quickly. 2019, there were only 600 defendants on bond that were required to wear an ankle monitor. 600. 4 years later, we're now at over 11,000. I mean, if I bought stock in the amount of offenders required to wear an ankle monitor, my investment would have made me rich beyond wildest dreams. This is why this is imperative, that this information be transparent and not have to wait days and days. So we urge support of this legislation.
Any questions for Mr. Khan? Okay, thank you for being here. Oh, Ms. Jones has a question.
Hey, Mr. Khan. Good morning. Thanks for
Morning.
being here. So it seems like the bill requires prompt notification to the court, right?
Correct.
But I don't see where this bill requires prompt notification to the victim, which I think might be helpful, right? To know if somebody who is alleged to have done something to me, if they're not following the conditions of their supervision, then I might want to protect myself. So that's the one thing I don't see, and be curious to know why that was left out. And I know you're not the person, but I can think back to a case, I actually have a bunch of cases, but one in particular jumps out where the defendant was going where he wasn't supposed to go a lot. Didn't tamper with the GPS device, just did what he did, and ended up having a motion for bond violation, or do a bond violation report so that the state could revoke or try to get the judge to revoke the bond. And I just remember that process took a minute to file the paperwork and the judge to set it for a hearing. So are you concerned at all about the victim being notified? I mean, so I know they're doing it, it's just not as quick.
Yeah.
And then it took a minute to actually get the data from the GPS monitoring company that actually showed that he was
I think
doing whatever
it's frankly represented. I think it's opening up a whole other issue, because if you have victim notification on any defendant on bond for ankle monitors, where does that lead? Who's going to be responsible for notifying the victim? I see where you're going on this. From where I'm looking at this, the way I've always kind of used an analogy, if someone breaks out of prison, everybody knows, right? But if someone breaks out of their ankle monitor, nobody really knows on that.
And I would add, I think you may have a bit of a germaneness problem expanding it, but so you probably need to check on that before we do that.
I'll check on it.
Okay,
When
yeah.
I saw when I saw notification, I know
Yeah.
that they're already notifying. So
And
what-
certainly,
what-
we might look at doing an amendment on the floor if it doesn't hurt the bill.
Okay, all right, thank you.
Thank you. Appreciate it.
Anything else for Mr. Khan? Okay, thank you for
Thank you.
being here.
You bet.
Anyone else? Got one? No. Anyone else here to testify for, against, or on Senate Bill 1020? If not, the chair recognizes Sheriff Louderback to close.
Thank you, Chairman. If no other questions from the committee, I'll close.
And members, we have enough to vote this out if it's the will of the members here to vote it on. So Mr. Cook, you want to move that? Mr. Cook makes a motion that Senate Bill 1020 be reported favorably, referred to the Calendar Committee with a recommendation that it's passed. So Mr. Cook has made the motion. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money? Representative Moody? Representative Rodriguez Ramos? Okay. Representative Verdell? 3 absent. That's 8-0.
So by a vote of 8-0 with 3 absent, the motion prevails. And we thank y'all for being here. So at this time, the chair lays out Senate Bill 1120 by Senator Hinojosa and recognizes Representative Johnson to lay out and explain the bill.
Good morning, Chairman Smithy, Vice Chair Wu. Thank you for the opportunity to lay out Senate Bill 1120. I'm honored to join Senator Hinojosa and Senator Huffman in the effort to ensure the protection of rights of victims of family violence. During the last session, Senate Bill 409 was passed that granted victims of sexual assault, stalking, indecent assault, trafficking, and others the right to confer with the prosecutor on the disposition of the case. However, victims of family violence do not currently have those same rights. Passage of this bill would again allow those victims of family violence the opportunity to not only the right to confer with prosecutors for the disposition for family violence, but the right to disclosure of evidence collected during the investigation unless it would interfere with the investigation or prosecution, and notification that the prosecutor does not represent the victim, dispelling any confusion that the state's prosecutor represents the state and not necessarily the victim. This will ensure that family violence victims receive the same rights as other crime victims. Happy to answer any questions or would reserve the right to close.
Thank you. Any questions for Ms. Johnson? If not, we do have a couple of witnesses.
Thank you.
And we'll certainly permit you to close as well. So the chair calls Chair calls Jennifer Mudge.
Hello, my name is Jennifer Mudge. I'm a public policy manager with the Texas Council on Family Violence. I'm also a former legal advocate who worked directly with survivors. I'm here today testifying in strong support of SB 1120. Thank you, Representative Johnson, for authoring this bill, as well as Senator Hinojosa and Senator Huffman in the Senate. And thank you, committee, for the chance to speak. As we've just heard, SB 1120 would give family violence survivors the right to request that the prosecutor confer with them on disposition decisions, including plea agreements. This is a right that's already afforded to many other types of survivors, and family violence survivors should not be a group that's the sole group that's excluded from having this right. We know that family violence is an intensely personal experience, but at its core, it's driven by one partner seeking control over the other. Without a voice in the criminal justice process, survivors can be left feeling like they are once again being silenced or controlled. I've seen firsthand the importance of having this right to a voice. When I worked with survivors who were already involved with the criminal justice system, Some did not want to testify because no one talked to them about their experience or asked them what they wanted to see happen. Others felt less safe than before the case started because an offense was pled down or dismissed and they were never consulted. These were missed opportunities for safety and justice. However, when survivors had the opportunity to share their experiences and have their needs considered, it often helped restore a sense of control. When the prosecutors spoke with survivors, it opened up a crucial opportunity for survivors to share their safety concerns and their needs, and for them to get connected with life-saving resources like shelter, counseling, and advocacy services. Having that trust and communication helped survivors feel safer and more supported, and in turn more willing to testify and engage in legal proceedings, which strengthened offender accountability. Ultimately, conferring with the survivor reinforces that they matter, that what happened to them is being taken seriously, and that justice cannot be fully served without prioritizing their experience. Justice requires not only holding the offender accountable, but also working to ensure the survivor feels safe and supported and that justice was served. SB 1120 will do just that.
Thank you very much. Any questions for Ms. Mudge? Appreciate you being here.
Thank you.
We also, the chair would call Audria Maltzberger. Oh, wait, Ms. Mudge, could you come back up for one moment? I neglected to do what I need to do, and that is to say that according to your witness affirmation, you are Jennifer Mudge. You are here on behalf of the Texas Council on Family Violence, and you were testifying for the bill, correct?
Yeah, that's correct.
Okay, thank you very much. Sorry about that. And so now the chair calls Audria Maltzberger. Appreciate you being here.
Thank you. Good morning. Thank you for the honor of speaking with you today. My name is Audria Maltzberger, and I am a survivor of domestic violence at the hands of my former partner.
Okay,
I'm here
now let me, I need to do my business here. You are Audria Maltzberger, which you've confirmed, and you're
Yes,
here
sir.
testifying on behalf of yourself for the bill, correct?
Correct.
Thank you.
I am here to register strong support for SB 1120 related to survivors of family violence having the right to confer on possible plea agreements. Thank you, Chairman Smithy and the committee for providing me the opportunity to speak today. I am a constituent in Representative Cook's district and would like to thank Representative Johnson, Senator Hinojosa, and Senator Hoffman for standing with survivors of domestic violence by authoring this important bill. As a survivor of domestic violence, I can say that this bill will help save lives. I'm here today to share the impact that this bill could have had on my life and can have on the lives of many victims of domestic violence. I was in an abusive relationship that lasted for 12 and a half years, and in the end, it took broken bones for me to leave. When I finally found the strength to leave, I left with my 3 children, a laundry basket of clothes, and drove more than 8 hours to Fort Worth to find safety at Safe Haven of Tarrant County's emergency shelter. At the time of his criminal proceedings, I was not given the opportunity to discuss the plea agreement offered to him and was only notified of the outcome after he accepted the plea. The outcome of this plea agreement was a reduction from felony assault to a mere misdemeanor, along with court-ordered batterers intervention classes. This result felt like yet another act of abuse that left me feeling broken and even more terrified. I feel that this was a lost opportunity to support my safety and have my voice be heard, while also sending the message to him that this charge was a serious crime and hold him accountable for his actions. If someone would have consulted with me regarding this plea agreement, I could have experienced a moment of choice and agency, but instead experienced re-traumatization when I was told of the outcome of this plea agreement. As the person most affected by his acts of violence, my voice and safety needs should have mattered. Although I did not have that opportunity at the time, I am proud to now be a voice for those who have not found theirs.
Okay, let me, Ms. Jones has a question for you.
Yes, ma'am.
I actually want to say thank you for sharing your story.
Thank you.
And I'm sorry that you had no part in deciding what happened to your abuser. I actually think, just based on my experience, and Rip Johnson can listen to this, I think that it's better that the DA's office contacts the complaining witness or the victim way before trial. which has been my experience, that they barely talk to them the week of trial. And I just think as a lawyer trying to prepare for a case, you need to know things. You need time to
Absolutely.
digest those things. And oftentimes, I'll find out things because I represent victims, try to navigate the court process.
Right.
That I'll know things when I'm speaking with them, and like the DA doesn't know because the DA didn't bother to call them to find out, which actually could make it easier for the DA to convict them most times of something more serious. And so I think procrastination on the DA's part ends up constituting an emergency on the victim's part
Right.
at the end of the day. So I think this is a great bill. And again, I know that there's not a time frame from when the contact needs to happen. And I read in the bill, it says the victims have to give you their contact information. Well, they always do that. Victims assistance generally deals with them. And then after that initial contact, right, when they're trying to get you to get an order of emergency protection, which is what I normally see, like
Right.
you want a MOAB, you want a protective order, right? And then after that, it's like crickets. And then you literally don't hear about them again until later. And I will also tell you, as a survivor of domestic violence, sometimes we have to change our phone numbers because
Or
they know,
address.
and where we live, right? Because we're just trying to stay breathing.
Right.
And so because the DA's office really hadn't paid attention to you, by the time there's trial, they don't even know how to reach you, right? So sometimes they've got to dismiss the case because they don't know how to reach you because they basically dropped the ball. So I'd actually like to see eventually, maybe not now, maybe we do it in the next session, where there's a mandatory requirement that the DA's office talk to you more than precursorily at the beginning and then at the end, but sort of periodic during the course of the case, because they may be doing something. They may be trying to reach you, right? They may be stalking you on social media. They may be trying to turn the kids against you. There are all these things that happen that tend to show what they did and if they're trying to control. So I think this is a good bill. I think it's a good start, and I'd really like to thank you for sharing.
Thank you. I appreciate that so much.
Oh, wow.
Any
You're
other
welcome.
questions for Ms. Maltzberger? Okay, thank you for being here.
Thank you. I appreciate it.
Very much.
It's been an honor.
Is there anyone else here to testify for, against, or on Senate Bill 1120? Chair seeing none, chair recognizes Ms. Johnson to close. I'm sorry.
No problem. Thank you, Chairman. Again, want to thank the witnesses who came to testify, and obviously this is an indication from the state of Texas that victims of sexual assault or domestic violence need our greatest trust and treatment within the criminal justice system. I would ask your favorable consideration. Thank
Any
you.
questions for Ms. Johnson? Okay,
I
so,
close.
members, any objection to voting on this now? Anybody have a problem? Okay, if not, Ms. Jones moves that Senate Bill 1120 be reported favorably and referred to the Committee on Calendars with a recommendation, be printed with a recommendation that do pass. Clerk, please call the roll.
Chair Smithy? Sorry. Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback?
Aye.
Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? That's three.
Okay, thank you, members.
8-0.
By an 8-0 vote, the motion prevails, and thank you all for that bill. And so we have one more bill left, and this is I'll go ahead and lay this out. This is the chair lays out Senate Bill 1537 by Senator Zaffarini. This is a bill that's really just a technical correction. It deals with interpreters in criminal proceedings. Right now, the Article 3830A of the Code of Criminal Procedure has a provision that when a witness does not understand and speak the English language, an interpreter must be appointed. Right now, there's no other language in Article 3830 that deals with the qualifications of the interpreter, but there is language in the government code, in Chapter 57 of the government code. So all this bill does is incorporate that language into, from the government code into the Code of Criminal Procedure. And basically, it has 3 qualifications for an interpreter that can be appointed, 3 exceptions to the rule that the interpreter be a licensed interpreter. One is that in a county of fewer than 50,000 population, and there's no licensed interpreter available, the court can appoint another interpreter who is not licensed. Another is if the witness or the defendant speaks a language other than Spanish, and no licensed interpreter is available speaking that language within 75 miles, they can find another interpreter who's not necessarily licensed. And the third thing would be a non-licensed interpreter who qualifies with the court as an expert, according to an expert witness that meets those qualifications. That person could then be qualified as an interpreter. So those 3 exceptions are already in, as I say, in the government code, but we would just go ahead and incorporate those in the Code of Criminal Procedure. If anyone has any questions, I'll be glad to address those. Okay. If not, we don't have anyone registered on the bill to testify. Let me ask, is there anyone here to testify for, against, or on Senate Bill 1537? Appearing to be none, appearing none, the chair will simply close on the bill. Is there anyone who has any objection to voting on Senate Bill 1537? If not, Mr. Moody moves that Senate Bill 1537 be reported favorably, referred to the Committee on Calendars with a recommendation that pass and be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback?
Aye.
Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 9-0, 2 absent.
Okay, so a 9-0 vote, the motion prevails. We do have more members here now, and so at this time, the chair would recall Senate Bill 664 by Senator Huffman that was laid out by Representative Cook. And if you'll recall this morning, this bill relates to the qualifications, training, removal, and supervision of masters, magistrates, referees, associate judges, and hearing officers. And if there's no problem with that, we'll go ahead and vote. So Mr. Cook moves that Senate Bill 664, there was a substitute on that?
No.
Okay, no, sir. That Senate Bill 664 be reported favorably and referred to the regular calendar with be printed with a recommendation that do pass. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money? Representative Moody? Representative Rodriguez Ramos? And Representative Verdell? Sorry, doing math. 9-0, 2 absent.
By a 9-0 vote, the motion prevails. Members, also this morning, the chair recalls House Bill 3207 by Mr. Dean. We didn't vote on that. Ms. Jones, I know I said I'd give you more time to look at that, but if you, are you a no on that?
House J. Dean's bill. 3207.
Representative Dean's bill, House Bill 3207. If we have enough votes, we might. Okay. Well, let's go ahead and see where the votes are. Mr. Cook moves that House Bill 3207 be reported favorably, referred to the calendar with the recommendation that do pass be printed. Clerk, please call the roll.
Chairs, oh,
Sure, okay.
Mr. Chairman.
Because the motion's withdrawn for now. Okay.
And this really is discussion, not persuasion.
Yep.
But it's intoxication assault. So someone someone's driving a motor vehicle and they happen to hit a police officer or a judge, I guess. Why is that an enhancement over driving and hitting someone else? They're intoxicated. They don't know what they're doing. They're not targeting someone, probably. They're just slamming into whoever is there. I'm trying to figure out why that is an enhancement. And I've got an uncle who's a justice of the peace. I've got, police officers in my family. I want to protect people, but this seems a little different than some of the other enhancements for that, where people are targeted.
Okay, and I will say, we do have precedent in our criminal statutes where we apply different penalties based upon who the victim is. Now, I'm not saying that's good or bad. I'm just saying
and I
it's
generally
not
understand.
unprecedented, but-
I'm sorry.
But anyway, that would be, only explanation I would have. Okay, now Ms. Jones has a comment.
So,
Before you do, let me recognize Representative Bowers, who's joined us. Okay, I'm sorry, go ahead.
so even like, for example, with a capital murder charge against someone with law enforcement, that enhances the penalty, but you have to intend, first of all, you have to know the person is law enforcement, and you have to have intentionally and knowingly did what you did. So what if a judge is in plain clothes? What is if an officer is in plain clothes? I literally can remember a case that I had in a capital murder where my let's just say that the person was charged with knowingly trying to do harm to law enforcement, the uniformed officers, right? But they were also undercovers. And the person was not charged with, they were charged with assault but not attempted capital murder of uniformed officers in that one because they didn't know that the uniformed officers were law enforcement. And so I equate those, so they were charged with two things, like charges for the uniformed officers and then charges for the undercover, and one had a more severe penalty than the other because the person knew, the defendants knew that the ones were uniformed and they didn't on the others. And I think that's appropriate. So I think my concern here is I could kill a law enforcement officer, not know it's a law enforcement officer, and be enhanced.
Okay.
So I'd like to have a knowing requirement that they knew that they were doing whatever, like the person was uniformed.
Okay. Mr. Louderback?
Committee, we have several ways we can take care of this as far as normal business prior to this bill. But intoxication, manslaughter, aggravated assault with a vehicle, all those things are possible in the way prosecutions handle them now. But we've known for quite some time that police officers directing traffic are more at risk, simply because the lights seem to, for lack of a better explanation, the lights seem to draw people towards the lights. So we've had a number of ambulances struck. In my county, we had a horrific accident where a driver ran right in the back of an ambulance and destroyed it with the lights were on. And so it just seems to happen over and over and over again. So this bill really clarifies and codifies to a better clarification standpoint about what's going on.
Well, let's don't spend too much time, because if we can vote, we won't have to come back, so,
All right.
on other things, but.
I'll just say really quickly, I don't have a problem with that, Rep. Louderback, because I know an ambulance is an ambulance. I know an officer directing traffic is an officer. My question is, if the person is not, if the law enforcement officer is not directing traffic, if the law enforcement officer is not at an ambulance and a law enforcement officer happens to be driving and I hit that person, I think there should be a distinction, because on the one, you know or you should have known, on the other, you don't. And that's what I'm
But if you're
saying.
intoxicated, you just hitting something.
Okay, how many no's do we have on this?
I'm going to be a no.
Okay. And-
I mean, I would just point out that it is bodily injury to a peace officer while the officer was in the actual discharge of an official duty. So, I mean, again, just want to make sure everybody saw that.
Can I just,
But that still doesn't address like undercover.
I'm sorry, Mr. Wood?
I would think an undercover officer deserves the same protection as a uniformed officer. That's just
Right, but you don't know it. I mean, like I said, you
The,
don't
the
know.
base level offense is by accident, it's an accident.
Right.
So you're not going to ever get to intentional. I mean, the intentional act is you got behind a wheel while you're intoxicated and then something happened. It's an accident or mistake. Including intentional here is incongruous with the base statute. The main point of this bill is to add bodily injury, because right now, intoxication, assault, you have to get to serious bodily injury, right? So what they've done is they've added bodily injury into all these provisions, and then we have a ratchet up provision under the base law. For officers today, you ratchet up to first-degree felony if serious bodily injury. And so they said if we're going to add bodily injury, which is a lesser degree of harm, then they're also creating a ratchet up for peace officers that sits, I think, at a second-degree felony under this bill. So it's just adding bodily injury, and then it's tracking past decisions. Whether we want to keep making those decisions is up to us, but it's tracking past decisions on how those penalties ratchet up. But that's, I mean, the real import of this is we are adding bodily injury to intox assault. It is a much, much, much lower bar.
yeah.
Can I say
The-
something
the-
to that?
Wait, the standard for bodily injury, for those you don't know, is pain. It's pain, that's it. You just have to, it just has to hurt a little bit. I flick you on the hand, did it cause pain? Yes, that's an assault.
Yeah, I was going to say, you know, if we're using LeBron James standard, anything is a bodily injury. But what I was going to point at, now, in all seriousness, you know, you drive past cops now, their LED lights are so bright you can't even tell where people are standing, and you're just hoping that they're not standing further away from their car when you go by. And so that's one of my concerns there. And what Representative Moody's talking about is reducing it down to just bodily injury. When we could get into, if you accidentally hit the person's hand when you're going by it, they could claim bodily injury now, which I don't like that. So now you're facing a felony for hitting a law enforcement officer's hand or something. So, yeah.
Okay. I need to, Ms. Rodriguez-Ramos, you were hiding. Okay, so did you need?
Oh, no, she's present now.
I've noted that. Okay. All right. Ms. Bowers has a question.
Question.
Thank you. Thank you, Mr. Chairman. Representative Verdell, I think, was alluded to what I was wondering, not having been here with you all this morning. I'm just wondering about what the increased penalty is. That's where I was with it. So it takes it to a felony?
State jail.
State jail,
The base level will be a state jail, and then it moves up from there.
depending upon, depending on,
Well, bodily injury would become a state jail.
okay,
And then
got
serious
it.
bodily injury still stays where it's at.
Okay, that's what I was wondering. Thank you. Thank you for the
Okay.
clarification.
Thanks. Any other discussion on it? How many no votes do we have? 4 no? Oh. Okay. Okay. 6, okay. All right. 654. Okay. Okay. All right. Yeah. So let's go ahead and vote it. Let's, as a House bill, it's on life support already anyway. So, okay. So, Mr. Cook moves that.
Transfer it to another hospital so it's not on our.
Mr.
It is House Bill 3207.
Okay, Mr. Cook moves that House Bill 3207 be reported favorably, referred to the full House with recognition that be printed, do pass. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
No.
Representative Little?
Yes.
Representative Louderback? Representative Money?
Yeah, yes.
Representative Moody? Representative Rodriguez Ramos?
No.
Representative Verdell?
Present, not voting.
so we have 1, 2, 3, 4, 5, 6 ayes, 2 P and Vs, and 1, 2, 3 noes.
Okay. By a 6
Three.
aye, 3 no, 2 P and V vote, the motion prevails. So one other matter, the chair needs to announce that it's referring Senate Bill 1980 to the subcommittee on new offenses and change penalties. And then we've got some votes to cast. First, the chair lays out as pending business House Bill 108 by Representative Plessa. This is a bill that we brought up, I think, in our last meeting, there weren't the votes to pass it. There is a substitute. Ms. Jones offers the substitute to House Bill 108. Is there any objection to the adoption of the committee substitute? If the chair hears none, the substitute's adopted. Representative Jones moves that House Bill 108 as substituted be reported favorably. The full House with recommendation that do pass be printed. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Aye or no? Aye. Representative Money?
No.
Representative Moody? Aye. Representative Rodriguez Ramos? Aye. Representative Verdell?
Nay.
8-3.
By an 8-3 vote, the motion prevails. Next, the chair recalls House Bill 316 by Representative Perez from the
8-3. 4 noes. I have
Little, Verdell, and Money.
Little, Money, and Verdell as noes.
He was a mo.
Are we right? Okay.
We're good.
Okay.
So was the vote count right?
Yes.
Yes. So the chair once again recalls House Bill 316 by Representative Perez. It's from the Subcommittee on New Offenses and Change Penalties. And the chair recognizes Representative Louderback to explain the measure.
House Bill 316 relates to creating a criminal offense for interfering with a motor fuel metering device or motor fuel unattended payment terminal in the prosecution of certain organized criminal activity. Subcommittee heard this bill on April 3rd, 25. No motion was made to recommend this bill to be considered by the full committee.
Okay. So Representative Louderback moves that House Bill 316 without amendments be reported favorably to the full House with a recommendation that do pass and be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Yes.
Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
Nay.
10-1.
Okay, so by a 10-1 vote, the motion prevails.
That's fine.
Okay, at this time, the chair moves to reconsider the vote that the committee took last week on Senate Bill 40. Is there any objection to the reconsideration of that vote? Okay, okay.
I thought that was approved.
It was. We've got, and I'll explain.
Is it back or?
Yeah, so the motion is to reconsider any objection. If not, the vote is reconsidered. Members, let me explain. This is the bill by Senator Huffman that dealt with cities paying and municipalities paying expenses of bonds, bail bonds for defendants. And one of the things that was in the bill, in the Senate bill, as it came over to us, it applied to nonprofit payments to nonprofit entities. We inserted in our substitute for-profit as well. We have been told that amendment, that change would not be germane. It would subject the bill to a point of order. And so we've gone back essentially to the Senate version now. And so that's the reason for the reconsideration. So
The amendment, which amendment?
It was the new
there was no
committee
amendment. It was a
substitute.
subcommittee
That's it
substitute.
last night.
Committee the change in the committee sub was that, the change in the committee sub was that loser pays? Was that the change?
The substitute had two things, as I recall, two major changes. One was we applied it also to for-profit bail companies, and also we did the loser pays instead of just the city pays.
The nonprofits was not germane.
Right.
But the loser pays
Yeah,
is.
loser pays, I think, is
Fantastic.
fine. And so there is a new committee substitute, so the chair lays out the substitute to Senate Bill 40. Any objection to the adoption of the substitute? Chair hears none. The substitute's adopted. And so Mr. Louderback moves that Senate Bill 40 as substituted be reported favorably, referred to the full House with a recommendation that it do pass.
Since we voted on it sub last time, do you have to withdraw that sub to adopt this new sub?
I don't think so. Well, let me back up for just a second. We had a substitute before, so the chair moves to withdraw the original substitute by which it passed prior to reconsideration. Any objection to the withdrawal of that substitute? There being none, that substitute's adopted. Now the chair offers the substitute to Senate Bill 40. Once again, is there any objection to that substitute? There being none, that substitute is the new substitute for Senate Bill 40 is adopted, and Mr. Louderback moves that Senate Bill 40 as substituted be reported favorably to the full House with a recommendation that it do pass, be printed. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Yes.
Representative Jones?
No.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
Aye.
9-2.
Okay. So by a 9-2 vote, the motion prevails. Next, the chair lays out House Bill 437 by Swanson. This is a bill that the subcommittee on, the chair recalls House Bill 437 by Representative Swanson from the subcommittee on juvenile justice. And the chair recognized Representative Cook to explain the measure.
Thank you, Chairman. We heard House Bill 437 by Representative Swanson on March 20th, which requires TJJD to place youth in detention or correctional facilities according to their biological sex. The subcommittee voted 3-2 to recommend that it be returned to the full committee with favorable consideration.
So Mr. Cook moves that House Bill 437 without amendment be reported favorably to the full House with a recommendation that do pass be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Yes.
Representative Jones?
No.
Representative Little? Representative Louderback? Representative Money?
Yes.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
Aye. Oh, I was going to say something else.
6-5.
So by a 6-5 vote, the motion prevails. Next, the chair lays out House Bill 507 as pending business. House Bill 507 by Representative Gervin Hawkins. This is a bill we heard last week that relates to policies and standards for providing legal representation to indigent defendants in certain capital felony cases. Ms. Bowers moves that House Bill 507 without amendment be reported favorably to the full House with a recommendation that do pass be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? 507.
Yes.
Representative Bowers?
I'm sorry, was that aye?
Representative Cook?
No.
Representative Jones?
Yes.
Representative Little? No. Representative Louderback? No. Representative Money?
No.
Representative Moody?
Aye.
Representative Rodriguez Ramos?
Aye.
Representative Verdell?
Nay.
3, that's a 6-5.
So by a 6-5 vote, the motion prevails. Next, the chair recalls House Bill 689 by Representative Gervin Hawkins from the Subcommittee on New Offenses and Change Penalties. Recognizes Chairman Louderback to explain the measure. 689.
House Bill 689 relates to increasing the criminal penalty for certain offenses committed in a vehicle operated by a public transportation system. Subcommittee heard this bill on May 1, 25. No motion was made to recommend the bill to be considered by the full committee.
Okay, so Chair Louderback moves that House Bill 1347 without amendment be reported favorably.
689.
Okay, sorry. Chair Louderback moves that House Bill 689 without amendment be reported favorably to the full House with the recommendation that do pass be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Yes.
Representative Jones?
Aye.
Representative Little?
No.
Representative Louderback?
No.
Representative Money?
No.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
Nay.
Sorry. Is that 8-4? 7-4. 7-4.
By 7-4 vote, the motion prevails. Next, the chair lays out House Bill, the chair lays out as pending business House Bill 1418 by Representative Schatzline. This is a bill we heard a couple of weeks ago that relates to the use of in-custody informant testimony in a criminal trial. Mr. Little moves that House Bill 1418 without amendment be reported favorably to the full House with a recommendation that do pass be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
This is 1418?
1418.
No, I'm sorry. Yes.
You said yes?
Yes.
Okay. Representative Bowers? I'm so sorry. You say nay. Nay. Representative Cook?
Yes.
Representative Jones?
Yes.
Representative Little? Representative Louderback? Representative Money?
No.
Representative Moody?
Oh, wait, which one is this?
1418?
I'm sorry, I was looking at the wrong one. Can I change to a 1?
Sure,
I
we'll
was,
let you.
I was looking at a different number.
So I for 1418?
Yes.
Okay. Representative Moody?
Yeah, that's right. Yeah.
Representative Rodriguez Ramos? Representative Verdell?
Aye.
10-1.
By a 10-1 vote, the motion prevails. Next, the chair lays out, the chair recalls House Bill 1572 by Representative Campos from the subcommittee on new offenses and change penalties. The chair recognizes Representative Louderback to explain the bill.
1572. Did I forget it? I might have forgotten to do his script.
Nope.
I don't have.
This is related to mail theft and certain criminal offenses committed against an employee or contractor of a common carrier or delivery service delivering mail, increasing the criminal penalties. Heard in committee on 4/24/25.
1572.
Not voted.
1572. Okay, so Representative Louderback moves that House Bill 1572 without amendment be reported favorably to the full House with a recommendation that do pass be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Yes.
Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
Aye.
11-0.
Okay, by an 11-0 vote, the motion prevails. The, okay. The chair lays out as pending business House Bill 1820 by Representative Bowers. This is a bill we heard a couple of weeks ago that relates to the expunction of arrest records and files when a grand jury fails to find that a probable cause exists to believe that the alleged offense was committed. So Representative Moody moves that House Bill 1820 without amendment be reported favorably to the full House with a recommendation do pass be printed. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
No.
Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell.
Aye.
10-1.
Okay, by a vote of 10-1, the motion prevails. Next, the chair lays out as pending business House Bill 2309 by Representative Villalobos. This is a bill we heard last week that relates to the forfeiture of certain contraband and the authority of the Attorney General to bring certain forfeiture actions. 2309. The chair, Mr. Verdell moves that House Bill 2309 be reported favorably to the full House, where recommendation that do pass be printed. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
No.
Representative Bowers? No. Representative Cook?
Yes.
Representative Jones?
No.
Representative Little? Representative Lauterbach? Representative Money?
Aye.
Representative Moody?
No.
Representative Rodriguez Ramos? Representative Verdell?
Aye.
6-5.
So by a 6-5 vote, the motion prevails. Members, it's almost 15 minutes till the floor. So we have several bills we're on our list, we still have not voted on. Let me kind of poll the committee. Would you all rather have a meeting while the House is in session today to vote on those, or right after adjournment?
Lunch break, we can do.
Are we doing a lunch break today?
Yes.
Okay. Okay, so assuming we do a lunch break today, we will go ahead and give notice that we will meet at lunch break. Hopefully, when we adjourn on the House tonight, we will be able to go home. So,
You do the recess.
so we will,
We need to recess.
so at this time,
I guess, are you?
we're going to have to adjourn and then repost. So at this time, the chair, if there's no objection, the motion, the chair moves to adjourn. If there's no objection, we are adjourned.
Mr. Smithy,